Good afternoon, everyone. My name is Brenda Lammy. I'm Vice President at the Canadian College of Health Leaders. To orient you today just to the webinar and how we're going to work things. If you do have questions for the presenters, if you scroll down to the bottom of the screen, there's a Q&A box that you can click on and type your questions in there. And I will be moderating the questions after the presentation. I want to welcome both Brad Proctor and David Fraser to our webinar and express my gratitude for your time today in sharing your insights and knowledge with our audience. Brad Proctor is the office lead partner and David Fraser is the privacy lawyer and partner, both with McInnes Cooper. So I don't want to take up any time, so I'm going to turn it right over now to Brad and David.
Sure. Thank you, Brenda, and thank you, Amy, for inviting David and I. We're each just going to give you a little bit of perspective about our respective experience and the context of which we practice. So I just want people always to be aware when I present that I am a management side labor and employment lawyer, only because when I'm discussing, I don't represent the union side in my practice. So I just want people to be aware of that. As a practitioner, I advise all types of clients in all different industries. And I'll do things such as labor arbitration, health and safety, occupational health and safety defense work. So that's the experience and the background from which I'll be presenting. The other thing I will point out is we have designed this seminar to be generally applicable across Canada. So we're not being jurisdiction specific. So if you're asking a question about British Columbia or Saskatchewan, we're not going to get into specific details about specific legislative regimes. We're going to keep it generally principled along the lines of what is generally acceptable principles across Canada. Dave, did you want to add anything to your intro?
No, only just to say that so I practice exclusively in the area of internet and privacy law, with the largest part of my practice being privacy law. Across a range of industries, including in the healthcare sector, public sector, private sector, and so it's from that perspective and recognizing kind of who the audience is. We do have a patchwork of privacy laws across the country, and so I would just kind of reemphasize what Brad said. My comments are going to be focused on or based on what seem to be high watermark across the different jurisdictions in terms of best practices and principles to take into account. But there are some quirks from province to province, as many of you probably know.
Great. Okay, so let's move on in our slideshow. So, interestingly, I believe I was leaving a particular section of a session of collective bargaining about 3.5–4 weeks ago, and the collective bargaining was for a municipality, and it focused on usual things that collective bargaining focus on. And that would have been kind of around the early part of March. And from about that point onward, about everything that I have touched as a labor and employment lawyer has related to all things COVID. So we've been on this path now for the better part of 3 or 4 weeks as lawyers advising clients. And one of the things that I've noted is the type of lawyer that often people turn to are individuals in the labor and employment or privacy practice areas. Because we tend to be in touch where there are large groups of people working in workplaces. So as far as the road we're on it. As to when that ends, I'm not certain. The next slide that I'm going to show you is not, I don't want anyone to think this is accurate and they should act on it. This is simply a sample of the type of slides that in certain workplaces, and this is a little bit outdated, I'll point that out. This is probably about 2 weeks old now. And this is jurisdiction specific. This was for a particular workplace in Newfoundland and Labrador. But working with medical experts, employers are generally trying to ascertain, how long are we in this? How long do these restrictions last? Because these things are relevant when you think about your policies. If you have to suspend application of a policy, how long do I suspend that? If I have to temporarily lay off a staff person, how long might I have to temporarily lay off that staff person? So I simply display this slide to show that medical experts, based on previous pandemic curves, what some of the predictions they've been providing, which gives us some insight as employers or as advisors to employers of what we can expect as we go forward. Next slide, Dave. So we have tried to foresee And of course, we've gotten many questions over the last few weeks, you know, in questions that are repetitive. We get a lot of the same questions, but sometimes we'll get questions that are, you know, entirely new. And in some areas, we can apply application of law and knowledge and experience from previous incidents. I know we look back to H1N1, to SARS, and some of the measures we've implemented there, but in many ways, this is truly unique. And so with the balance of the presentation, what Dave and I have tried to do is collect some of the more frequently asked topics and questions that we've been asked in our respective practices. Next slide, please, Dave. So I prepared this little graphic about a week ago, and it's already dawned on me that I'm already missing at least one major area of law that's not in this circle. But if we think about the workplace and the various types of law that impact our workplace, I'm going to start with my kind of blue circle near the top, which is public health, which is perhaps the paramount area of law that we all need to be respectful and acting on. And that is the fact that in all of our provinces, we've had various declarations of emergency, various ministerial orders, various public health orders. And those are things that we are not just expected, but we are required to comply with as employers. And so that is kind of the paramount area of law that we need to, as employers, have at the forefront. I know in many jurisdictions across Canada, the public health orders and the directives, authorities are starting to enforce those. And what I mean by that is they're starting to fine and charge individuals that are breaching these public health orders, and they're charging corporate entities and organizations. So that's the first area. The second area is occupational health and safety. This is a health and safety crisis, and as employers, we all know in every jurisdiction in Canada, we have a legal obligation to ensure the health and safety of our workers. And one of the things about health and safety is it's a preventative, a precautionary area. It's not reactive. We don't say, hey, wait till an accident happens and then do something. The law says prevent the accident. Put in place precautionary measures that prevent the accident. Health and safety also goes a long way with employee morale. In many of the workplaces that I work in, you know, the health and safety, the measures you've adopted go a long way to having your workforce feel confident in coming to work. So if you're adopting practices or policies or procedures that are specific to COVID, make sure that they are in writing, make sure that they're communicated. If you're doing extra sanitizing, communicate with your employees so they have confidence in your health and safety measures. The next area is human rights law. The human rights law is basically two big things. Number one, we can't discriminate. So we can't particularly choose a certain gender or a certain ethnicity or a certain race and put special rules in place for them. And we also have to be very cautious with ages and things of that nature. We can't discriminate in the face of COVID. And secondly, we have to accommodate. So if we have individuals that are affected or could be affected, then we have to accommodate those human rights in the workplace. Another major area that we have is employment standards. So employment standards laws, they go by different names across Canada, but those come into play when we are deciding whether or not we can temporarily lay someone off, whether or not we have to provide them with notice, whether or not we are doing a mass termination. All of those things are employment standards issues. And you know, different workplaces, they apply differently. For example, this is not important to anyone on this call, but in most provinces, if you are a construction industry employer, most of the employment standards, or a lot of them with respect to layoff, don't apply to you. So different industries are impacted in different ways. Workers' compensation, of course, you have your Workplace Safety and Insurance Board in Ontario, where if someone contracts the disease in the course of their duties, they could have a claim under the applicable Workers' Compensation Authority. I will not steal any thunder on the next white circle, which is privacy. I will leave that all to David because he's the expert in that area. We then go over to employment insurance. And if there's anything that has been evolving literally by the day over the past 3 weeks, it's been the employment insurance world. About 3 weeks ago, the federal government made changes to the employment insurance sick benefit. Then they imposed a certain temporary emergency benefit. Then they've imposed yet the third benefit, which is the one that is Prime Minister Trudeau spoke about today, which is the Canadian Emergency Response Benefit. And so I can answer lots of questions on those issues, but that has been a significant area of evolution. If you're in a unionized workplace, of course, you have your collective agreement. And I have seen collective agreements. I have one on my desk here that I was advising a client on recently. And they have a clause in their collective agreement, which is very helpful in this type of situation. It says, the notice provisions of this article do not apply in the event of acts of God, unforeseen circumstances, or climactic or economic conditions beyond the foreseeable control of the company. That's helpful in the face of COVID. I've also seen collective agreements where employers have guaranteed certain complements and agreed that they will not lay off below those complements or limited their layoff rights significantly. So you need to look to your collective agreements. And last in my circle here is employment contracts. We're going to talk a little bit about constructive dismissal, and that's something that we need to be mindful of when we're looking at people's employment contracts. The circle, of course, that I left off, and there's probably a bunch more that I've left off, but immigration. Immigration is something that I did not speak about. I'm not an immigration lawyer, but it's an area that I've not discussed. Next slide, David, please. Thank you. So one of the things that we have to look to, and I get calls from clients quite often that operate in multiple jurisdictions. And I wish I could say to them that the rules and the regulations of what's required in a workplace is uniform across Canada, but it's simply not. There have been some applications of the Federal Quarantine Act in this particular COVID pandemic with respect to travel into Canada. But when it comes to what we can do in the province, and we're here speaking to you as healthcare professionals and healthcare leaders, in each of your provinces, it's the provincial law that regulates your workplaces and what you do, save for perhaps a few exceptions with some federal agencies and federally regulated employers. But for the most part, it's provincial law. And so you really need to look at what are the rules in place in your jurisdiction. I know many people from Quebec and Ontario will call and say, you know, we're deemed to be an essential service or an essential industry. Well, some provinces aren't taking that approach. Some provinces are declaring certain industries to be essential. Other provinces aren't doing that. Other provinces are specifically shutting industries, and if they're not shutting you, then I guess you're deemed to be left open, but they're not necessarily calling you essential services. So when you think about the world we live in, and if I'm a large organization that has operations in multiple provinces, I need to be aware of what the social distancing requirements, what the mass gathering requirements are in my particular province. And yes, there's a lot of uniformity. The whole 6'2" social distancing is fairly uniform across Canada. The minimizing any gatherings of less than 5 and less than 2 is fairly uniform across Canada, but certain provinces have done things differently. And certain provinces have given authority to the police to stop people from entering their borders, and some have not. Next slide, David. And so David used that phrase already, and I'll steal it from him. He said privacy is somewhat of a patchwork quilt in Canada, and that's what we're dealing with here when we have individuals working in multiple provinces. There is a patchwork quilt of taking things from the federal pronouncements and interlaying those with provincial states of emergency and various declarations. Okay, next slide, please. So one of the things, and I was trying to think about this is likely not something that you are worrying about necessarily in the healthcare sector, and that's a generalized statement. And I'll say it, if you are an executive or someone working with a hospital or public health or residential care facility, you're likely not contemplating layoffs right now. You're likely the opposite, struggling to find employees, to harness your casual workforce. But pretty much every other industry in Canada is grappling with this notion of layoffs. And I know that I've spoken to individuals in not-for-profits, oil companies, trucking firms, retail, you name it. And layoffs are something that they're asking questions about. In particular, I would say kind of the regulated health professions. So from my experience, I have dealt with optometrists, dentists, massage therapists, lots of those individuals that have been ordered to close. So they've actually been ordered that you cannot practice dentistry in this province except for emergency services, or you cannot practice this or that or the other. And you know, the emergency services, those don't keep the full staff complement going. So they've needed to contemplate layoffs. Now, when it comes to layoffs, what I advise clients to do is to try and gather their information. So I say, you know, create some type of a spreadsheet where you list your workforce and start looking at the issue of whether or not you have a written employment contract for those employees. If you're in a unionized working environment, well, then you go to the layoff provisions under your collective agreement. Because you want to look at the employment contract for a couple of reasons. In many cases, people like me, management side employment lawyers, for the last 15 years, we've been telling folks that own their businesses or that are in human resources that you should have written employment contracts with employees. And the reason for that is employment is among the most important relationship people have in their lives. And so without written employment contracts, it leaves too much to chance. And so those employers that have written employment contracts, and in some cases, it may say, you know, we hope we have a long future together as employer and employee, but if our relationship ever needs to end, we can do so by giving you the minimum of the provincial employment standards legislation in the province. If you have that type of contract, then a lot of the stuff that we're going to talk about when it comes to constructive dismissal doesn't really apply to you because you've already, in effect, contracted out of the common law. But if you don't have those types of contracts or don't have those types of clauses, if you're looking at a layoff, you're going to have to look at two things. Number one, what is the employment standards statute say in your province? And then number two, if you don't have a contract, what about the common law? And let me just mention quickly about each of those things. In virtually every province in Canada, the employment standards legislation is somewhat similar, but in many ways it can be different. And here's the reason. So let's take the province of Ontario, for example. In Ontario, in your statute, the Employment Standards Act, there is an ability to temporarily lay off employees. If you temporarily lay off an employee for a certain duration of time, one of the durations is no more than 13 weeks in a 20-week period, then you don't attract the requirement to give the statutory notice or the statutory severance under the Employment Standards Act. However, in other provinces, they don't have that temporary layoff provision. For example, in my province, Nova Scotia, and the neighboring province, New Brunswick, where I do much of my work, we're only allowed to temporarily lay off people for 6 days. After 6 days, then it's deemed to be a termination or a permanent layoff. So that's one thing where the provinces differ. The next thing that most provinces will have a clause in their employment standards legislation which exempts application of the employment standards legislation in what I'll say are called circumstances beyond the employer's control. And many regulators in Canada have already given some pronouncements on those, and some have not. In my home province, Nova Scotia, there's been no pronouncement of whether or not the pandemic, current pandemic, is a circumstance beyond the employer's control. So it's left to employers to take the risk. Well, should I provide notice or should I not? Is this something that's beyond my control? For example, in neighboring New Brunswick, their government has come out and said publicly that they view this current COVID pandemic as a circumstance beyond their employer's control, and employees can be laid off temporarily without notice. Lastly, when it comes to employment standards legislation, most provinces have a threshold for what we call mass termination or mass layoff. And so that's where you lay off more than X number of employees in a certain time period, and that often requires heightened notice and written notice to the Minister of Labor, the Ministry of Labor in your province. Once again, you need to look at those provisions which explicitly could exclude you if this is something beyond your control. The last point I want to make about layoffs, and actually, Dave, if you advance to the next slide. So what I've just been speaking about is kind of the yellow box over on the left-hand side of your screen, the employment standards legislation. You got to look at it by province. Do you allow for temporary layoffs? individual mass notice and exceptions beyond your control. For people that don't have an employment contract or their employment contract doesn't contract out of the common law, there's the risk of actually constructively dismissing. Because at common law, unless it's written in your contract, you do not have the right just to lay someone off. And so it's possible that in temporarily laying someone off, they could claim that they've been constructively dismissed. And if they do that, of course, what they're saying is I'm effectively severing my employment relationship with you, employer, and I'm suing you for the notice I would have gotten had you terminated my employment. Now, in this climate, I have not seen any cases of alleged constructive dismissal yet. Why is that? Well, I think most employees recognize the situation that the world is in, that the country's in, that their employer is in, and most employees recognize that the layoff that they get is temporary, and they're hoping to maintain that relationship with their employer in a hope to be recalled and come back to work. I don't think a lot of employees are thinking it's a good time to necessarily put themselves on the job market, because as we know, except for maybe cleaning contractors who are COVID certified, there's not a lot of employers that are kind of ramping up and hiring. So thus far, I've not seen a lot of claims of constructive dismissal, but that's not to say that they won't come. And there are different risk mitigation strategies you can put in place, having a good relationship with your employees, communicating with them regularly, and in certain cases, having a supplemental unemployment benefit plan can help in that regard as well. Although that is a current issue that's questioned with the federal government's latest benefit. And then, of course, if you are unionized and you have a collective agreement, well, you don't really need to worry necessarily about the other two boxes. You go to your collective agreement and you look at the provisions that have been negotiated between the employer and the union with respect to layoff, and you proceed in that regard. Next slide, David. So with respect to layoffs, the last, I would say, couple of weeks have been rapidly evolving, and I heard a couple of legislatures. I've been attending calls regularly every 2 days with a number of provincial government officials and a number of federal MPs. And I've heard this phrase stated a few times now, that legislators are legislating in real time. And that's what they're doing. So when we think about the Canada Emergency Response benefit, it says plan, it should say benefit. That is something that was announced about a week to 10 days ago. And there was an act of parliament which was promulgated. So we have the legislation to look at. But as far as the regulations go, we just don't yet know what the regulations are on the Canada Emergency Response benefit. And that's something that, if you're following the media, that opened for application on Monday. So on Monday, April 6th, laid off employees started applying for the CERB. And there's a whole bunch of unanswered questions about the CERB, but the few that come to mind really quickly are, for those employers that have put in place a supplemental unemployment benefit plan, which allows you to top up employment insurance, when they put those in place 3 weeks ago, or had them in place already, they never knew that there was going to be this new CERB created. And so the new CERB, there's a question mark, is can I top that up with a sub-plan which is specifically designed for EI? Another thing which has been evolving literally as we speak over the last day or two is, under employment insurance, employees can still work a few hours and they'll have a slight clawback. There's a calculation for the hours that they earn on top of their EI. But up until 2 days ago, it was stated that the CERB, you cannot work. Now, yesterday, the federal government announced that they're going to allow a limited number of hours to be worked while someone is on a CERB. So that's a question mark. And the other piece is that some high-earning employees under employment insurance could earn $573 per week, whereas under the CERB, the CERB, the maximum is $500 per week. So some employers would like their high-earning employees to be able to get the maximum EI benefit, but the federal government is driving all new applications through the CERB. So as I mentioned, legislation is happening in real time. There's, of course, the Federal Work Sharing Program. That's not a new program. That's also through Service Canada and also with support of employment insurance. That has been amended and expedited to make it a little more limber, I guess I would say. It's a fairly complex plan, and there's all kinds of information online about the amendments. So that's been kind of expedited a bit. I've already mentioned a little bit about supplementary unemployment benefit plans. Those are things that you have to file as an employer in advance of laying people off, in advance of them getting EI, if you want to top up. So if you're in a workplace now and you say, yeah, geez, when someone goes off on parental leave and gets their EI and we top them up, that's because you have a sub-plan already filed for that purpose with Service Canada. But that parental leave sub-plan wouldn't necessarily apply here. And last but not least, one of the newer things which is evolving is the Canadian Emergency Wage Subsidy. That is the wage subsidy that if you can show a 30% decline in your revenues, then you can apply, and it's structured in 3-month tranches. So the first tranche starts on March 15 to April 11. And to apply for that tranche, you'd have to show a 30% decline in your revenue year over year in the month of March, the calendar month of March, March 1, 2020 to March 1, 2019. And so if you can do that, you'll qualify for that first tranche. And there are 3 tranches of the Canadian Emergency Wage Subsidy in those 3 months of March, middle of April, middle of May, and middle of May to middle of June. As I say, that was announced, and there's all kinds of stuff in the media about it and on the federal government website, but we don't yet have an act of parliament to actually formally bring that into force. So we don't really know the laws and how it's going to work, and we don't have the regulations yet. I do believe today, I couldn't watch it all because I was preparing for this chat, but I do believe Justin Trudeau may have said something to the effect that the draft bill on that is circulating or is coming out imminently. So that's coming out. And I probably don't have a lot of people on this call which would be interested in this, but the question that's coming up is, lots of questions are, well, what if I have a number of business units or operating companies that all roll up into a common holding company? Do I have to show the 30% loss in the holding company at the top or in each business unit? We don't yet know. So there's all kinds of questions. And then every province has been implementing its own provincial income benefits, business supports, rent deferral arrangements. There's been all kinds of supports. Dave, do you have any, I'll just pause there for a minute, Dave, while I take a drink of water. And if you have anything to add, if not, we'll move on to OHS, which is the next slide.
No, nothing to add on this part. So we'll just click on to the next OHS issues, which I think are probably front and center in a whole lot of people's minds.
Yeah, so when it comes to the next issue, it's health and safety. And one thing I guess I would say, of all the industries of which I have had some experience and provide some consultation, I think the industry that in a way has the greatest potential risk could be, in my mind, or is the healthcare sector. But in a way, you actually probably started with an ability to understand kind of the risks and the hazards you're facing when it comes to healthcare. Where I'm seeing a total disconnect is in some traditional industries. If you think about some blue collar industries, whether it be a sawmill or where it be some industrial factory or it be the transportation sector. I mean, these are industries where, you know, the PPE as far as germs and things of that nature are just foreign. It's not something they think about. So when I go and I look at what's happening in some of the residential care facilities that I've been advising, the guidance from the provincial health authorities, the provincial departments of health, the provincial public health has been pretty good and pretty specific for healthcare workers. But when we think about this notion that health and safety in every jurisdiction in Canada, once again, yes, there are nuances in every province, but what I'll say the fundamental underpinnings are the same right across Canada. And it's the two sides of this kind of coin here, if you will, that on the one hand, it's the employer's obligation to prevent injury, to prevent accident, to prevent people from getting sick. So it's all reasonable precautions to ensure, which is a very high standard, ensuring something, the health and safety of persons at or near the workplace. And most provinces interpret that word persons quite broadly to mean not just my employees, but my independent contractors, my patrons. It can be interpreted much more broadly than employees. But what's often forgotten is that employees have a corresponding statutory legislated duty to protect their own health and safety and that of other persons at or near the workplace. And that's something that we have to often remind our employees if we're saying, we want you to do this self-screening, or we want you to self-isolate, or we want you not to attend the workplace in person. And they say, well, you don't have the right for me to do that. You say, well, yeah, we do, because in the health and safety legislation, you as the employee have an obligation not only for your own health and safety, but the health and safety of other persons at or near the workplace. Next slide, David. So when it comes to your duties, your reasonable precautions, your safeguards, I've had, as I mentioned, if I go online and if I look at what some of the things that have been happening in the healthcare sector, very specific, very detailed. I know there are all kinds of issues with respect to the availability of PPE and the appropriateness of PPE, but it's an industry that probably has, if you look to it, some of the best practice guidance. If you look at some other industries, they're just not as sophisticated as you have been. I know from my perspective, I don't just work in the healthcare sector, and so I've spent a lot of time helping what I'll say is employers in other sectors devise health and safety protocols. So just think of your average, office tower building. An office tower building that has employees, it has security, it has reception people, has building cleaners, but it virtually has, in some cases, thousands of different people that will be coming in and out of that workplace. And so how do we devise a health and safety procedure or protocol for that? So we've had some expertise and experience designing protocols or standards, as we call them, which the building would disseminate to its tenants and say, this is a standard that we expect you to have your own policies and procedures on that are equivalent or better. And if you don't have your own policies or procedures, then you need to adopt ours, that type of thing. I've dealt with situations where, you may be in the oil and gas sector where you sell furnaces to individuals, and you have contracts where if their furnace breaks, you need to go into their house and fix that furnace. And if that person is potentially sick, how do you deal with that? So things of that nature. And one of the stranger ones that I've dealt with, which I'm still working on, is potentially locking employees into a workplace. I won't give away the company name or the nature of the industry that they're in, but it's a very sensitive industry that, contaminants from outside can be very harmful. And so kind of locking people in to the workplace is something that is being considered. So one thing I have remarked about when you hear the public health officials commenting about workplaces is they are being quite, in many ways, complimentary in saying that workplaces are doing a lot of creative things to cope with individuals, to cope with these safety risks. The next slide, please, David. So this is a significant oversimplification of what's going on in workplaces with respect to individuals who are COVID positive. The one thing I've been saying to employers in multiple provinces about this issue is do not panic, because you are not, with a COVID positive employee, yes, you have to, all those precautions I mentioned about minimizing the risk of your employees, social distancing, all of those things, you have to abide by all those things. But if you have a COVID positive employee, the entity in the driver's seat is public health. And someone is going to be tested at a healthcare facility, and most often that the public health is going to be made aware of that positive case before anyone else. And then public health is going to immediately start that contact tracing program, where they're going to reach out to you as the employer, and they're going to start identifying employees that person has come in contact with, and they're going to take you through the applicable regime which is appropriate in that province. There's been lots of confusion in Canada over what that is, and that part of that is because we do have a national media. So if something is written based on the law in Ontario or the process in Ontario about, there's got to be such a duration of time and 2 negative tests, individuals reading that in Alberta or in Newfoundland might think that that's what applies to them, when all public health authorities are doing this differently, and some are involving tests before returning to work, some are not. Next slide, David. And I think I'm eating up David's time here in the Q&A, so I'm going to make this very quick. The last piece to talk about on OHS is, and many of you were well enough into this now we developed this deck a few weeks ago, and we've been tweaking it somewhat. But what I was advising people early on is I was saying, pull your health and safety materials off the shelf and familiarize yourself with your work refusal process, because you're going to have individuals, just like we did in the SARS epidemic and H1N1, where individuals will perceive their workplace as unsafe and will refuse to go to work. And in each province, we have a procedure for dealing with work refusals. Once again, fairly similar across Canada, usually based on 3 steps. Number 1, go to your supervisor employer, not satisfied, then go to your joint occupational health and safety committee, which is comprised of employees and employer and union, if you have a union. If not satisfied, then go to your Department of Labor. And so familiarize yourself with that process. And there's lots of cases that have been developed over the years on work refusals, dealing with things like the Norwalk virus, dealing with SARS, that you can get, you can understand how the legal tests in this area works. And the last slide before I turn it over to David is simply, if we advance one more slide, past that one, sorry, David, would be workers' compensation claims. In every province, once again, WHSCC in Newfoundland, WSIB in Ontario, we all have different, WorkSafe BC, I think it's called. We all have different words and terms, but if your workplace has exposed someone to COVID, then it's possible that they can file a workers' compensation claim for that. And you have a statutory obligation as their employer within usually 3 to 5 business days, depending upon your jurisdiction, to file that claim with the appropriate workers' compensation authority. So those were my points, the things that I'm seeing most commonly. And David, I know you're getting lots of privacy related questions, so I'll turn it over to you.
Great, thank you. Thank you very much, Brad. Yeah, so when looking at and speaking to an audience comprised of individuals who are working in the healthcare sector from coast to coast to coast, one thing that I'm always mindful of is that we have a patchwork, a mosaic, a mess of privacy laws that can be applicable. And they're generally based on good privacy practices, and there is a high watermark that one can find, but we do need to be mindful of the fact that there are variations among the different rules. And obviously you need to kind of refer to what affects your workplace and your place of business. So for example, federal works, undertakings, and businesses, and at least with respect to the workplace, are subject to PIPEDA, the Personal Information Protection and Electronic Documents Act. For the rest of the private sector, there's actually no privacy law other than in BC, Alberta, and Quebec, again, highlighting the patchwork, the mosaic, or the mess. Federal government agencies, and this includes the Department of National Defense and Public Health Agency of Canada, are subject to the Privacy Act and also elements of the Access to Information Act. In the provincial public sector, which also includes most municipalities, universities, schools, and hospitals, are subject to the Freedom of Information and Protection of Privacy Act of that province, or the Access to Information and Protection of Privacy Act, or Right to Information, anyways, but they're all generally similar. The health sector is actually a little bit different than most because of the application of personal health information statutes. And most provinces have a statute such as this. Quebec does not, BC does not, but most other provinces do, and there are some significant variations among them. And for those in the management side of the healthcare sector, there's complicating factors that would relate to whether or not an employee is also a patient. And so thinking about, well, in what context was this information collected? How will it be used? How will it be disclosed? But in Saskatchewan, there's even a quirkier thing where trustees in that province as employers are still subject to that statute with respect to their employee information. So you always want to have a good handle on kind of what is the legal framework in which you're operating. And hopefully through the next couple of slides, you'll get a sense of flipping through the statute and highlighting the particular provisions that can or will come into play. And I would reemphasize what Brad said as well, because this has come up in connection with being asked questions related to privacy law. In the pandemic, they've mostly intersected with occupational health and safety and questions about what information can be collected about employees. And certainly there was the possibility at the beginning of this pandemic when it was seen as being largely travel related, whether or not information related to the place of travel and perhaps there might be a possibility, not with any of my clients, of course, but there might have been a possibility of putting individuals of Asian descent under greater scrutiny. So you need to be very careful about how all of these rules are applied. And certainly we know, like if we cast our mind back to 3 months ago when everything was innocent and it was a much more simple world, there would be, very rarely would an employer ever be justified in asking for information related to an individual's diagnosis. Questions would come up in terms of accommodation and return to work related to capacity, but never would it, or very seldom would it ever be justified to ask kind of what their diagnosis was. Certainly under most circumstances, it wouldn't be reasonable to ask somebody what their temperature was, or even to force them to have their temperature taken before entering a workplace. But we're in different times where we're balancing the occupational health and safety imperatives that Brad spoke about against privacy interests. And given the current state of affairs, it shouldn't be surprising that occupational health and safety, when you're dealing with people's lives and lives in the community and lives in your facilities, that privacy might take a back seat, but we need to be mindful of how that all fits into it. And so what I have on this next slide is essentially what are the privacy best practices. And as I think I might have mentioned, kind of the high watermark among most of the privacy statutes. Most modern privacy statutes since the 1980s are based on an evolving set of fair information practices. They're really well articulated in the appendix to PIPEDA, but you'll also see that they're baked into most of our health privacy statutes. And the main difference between the public sector laws and the private sector laws is the private sector laws are generally based on consent and reasonable purposes, and the public sector laws are based on the legitimate interests that a government agency would have in collecting information. Generally designed for information about citizens, not as employees, but they apply in the same sort of way. And so we can go through this and think about it in terms of, so you're an employer or you have a workplace, you're concerned about the transmission of the coronavirus within that workplace, you're worried about admitting into that workplace individuals who are at risk or who might in fact have the virus. And so you're thinking of implementing a system where you're going to take people's temperatures before entering the premises and disallowing them to enter if they have a fever. Or having them every time they report for work, fill out a questionnaire. Have you been in contact with, have you traveled? All these other sorts of questions. And being mindful that what questions you would ask or what you would do, it's also a moving target. Certainly public health have been kind of downgrading the travel as a risk factor and upgrading kind of community contact. So the best practices, your collection must be justified, reasonable, and non-discriminatory. And so you need to think about, okay, well, we want to implement this practice. Is it justified? Is it legally justified? Is there a provision in the statute that we're subject to that allows us to do this? Is it reasonable in the circumstances? Is this a reasonable question that we can or should be asking, or a reasonable demand from an employee? Recognizing, as Brad said, that employees have an obligation to participate when it comes to the safety of their workplace. And is it non-discriminatory? So if you're going to be taking people's temperatures, take everybody's temperatures. If you're going to be doing screening questionnaires, ask them across the board. Also be mindful of employees and contractors and things like that. An organization that manages a workplace manages the ability of everybody to enter that workplace and under kind of just trespass law. And you'll want to be consistent in the way that you apply these rules. People should be given notice of the purpose. And this has two reasons. One is under private sector privacy laws, you have to have consent, and that consent is based on notice. But also, people want to know why their information is being collected, how it will be used, and to whom it will be disclosed. And I've also found in my 20 years of practicing in this area that if an organization is transparent about what the purpose is, they tend to be more honest and more forthright. And also in a situation where you really need to get your employees on board with the whole process, if you let them know exactly what's going on and what the purpose is and get them on your team, they're likely to participate more. And also, it's quite important that privacy is one of those weird areas of law that seems designed to protect people's feelings. People don't like feeling like they're being intruded upon or surveilled or things like that. And that has to do with their expectations. So notices really provide that expectation or calibrate that expectation for individuals. Collect the minimum amount of information and retain it. So for example, if an employer were just to screen temperatures, if you have an elevated temperature, you're not going in. If you're fine, you are going in. Do you want to keep a record of that? Should you be keeping a record of that? Or is there other information that would be better and more indicative of the risk? And of course, you should only use that information for those purposes and not for any secondary purpose. You want to think about the record keeping necessity that could be helpful in contact tracing, which is not something that ever would have come up 3 months ago. And then obviously, if the information is going to be used to make a decision about somebody, you want to make sure that that information is accurate. And so you don't want to exclude somebody from the workplace because of something that you hear through the rumor mill, for example. You're going to want to diligently investigate that. And likewise, if you're taking people's temperatures to exclude them from the premises, you're going to want to make sure that whoever's doing that knows what they're doing, that the equipment is reliable, because you might in fact be, you're going to be significantly changing somebody's conditions of work if they're told, nope, you have a fever, you're not coming into work for 2 weeks. And you're going to have to self-isolate. And then the question always comes up: what about disclosing information to government authorities? And what about, for example, we hear from time to time about businesses that have announced they're closing because one of their employees tested positive, and people want to know. There's a huge amount of curiosity in the community about, well, who was it? Particularly in smaller communities or smaller organizations. And as Brad said, when there is a positive diagnosis or a real risk, it's going to be public health who are in the driver's seat. They have the ability, pretty well consistently across the country, but your mileage might vary based on how it is set out in your provincial statute. And these we're generally talking about provincial statutes, to collect information in order to do their job, which is contact tracing and to determine the risk. Every privacy law in Canada allows the disclosure of information where required by law. And so if the public health authority has the legal authority to do it, to ask for the information, you have the ability to disclose it. I generally said, and in my office at work, which I actually haven't seen in 3.5 weeks, I guess, right in front of my door is a big doormat that says, come back with a warrant. And I tend to require and suggest to my clients that they require any information request being in writing. That's perhaps not reasonable when dealing with public health authorities in this particular environment, but you're going to want to document the conversations you've had just for your own diligence purposes. In these circumstances, take the lead from public health. They're the ones who know what they're doing. They're the ones who know what they're looking for, and they're the ones who are going to be contacting other people in order to trace those contacts. But for example, they might need to know who was in the workplace that particular day or over the last week. And one of the things that you might want to be thinking of is what information could you be creating or maintaining in order to assist with that function, in order to kind of narrow the pool of individuals who might have who might need to be contacted for contact tracing. And so in some cases, I'm thinking of timekeeping systems, sign-in sheets. Who was there at that particular time can be a critical question to ask. And if you create those records for that purpose, make sure they're only used for that particular purpose. And in some cases, building card access. People might not necessarily think about the records you're creating kind of behind the scenes when parkades are entered into using monthly passes and buildings are entered. And so that would be kind of hopefully an overview of the privacy principles that are at play. And I think we've left probably not enough time for questions, but we welcome questions.
Thank you very much, David and Brad. And I read the questions that were submitted prior to, and you've touched on almost all of them. There have been a few in the question and answer thing that I'm just going to read and let you answer. First one is from Angela Ryan. Is there anything for seniors to apply for emergency benefits? So emergency benefits for seniors, is there anything available?
So it's Brad speaking here. I can say federally, any benefits that have been announced federally are not tied to any particular age. So if that's a senior who is somehow employed or earning an income in some way, then they can apply for the Canadian Emergency Response Benefit. And that, as I mentioned, is still evolving, and I have not had a chance to go back and review what Justin Trudeau said today on that. But it's not requiring a traditional record of employment, or it's not requiring a traditional layoff. It's through an attestation process. So if you're a senior who's done some work in 2019 to the tune of about $5,000, you may have an eligibility to apply for that. As far as provincially, there are various programs. Obviously, I know those in Nova Scotia best, but as far as kind of a subsidy program, I'm not aware of what's going on across Canada and other provinces.
Okay, thank you. Another question from Anne Mason Brown. What are areas of legal risk to employers related to requiring healthcare employees to work from home? And what are the employees' obligations when working from home?
So when it comes to working from home during this, I mean, one of the things, as I mentioned earlier, if in the usual course, let's rewind and pretend COVID never happened. If I said to my employees, hey, go work from home, don't come to the office anymore, I'm taking away your office, I'm taking away this, that might be a constructive dismissal. But if we go back to my initial slide where I had my circles, and one of the things was compliance with public health, I mean, that's what public health is directing and mandating. So we are justified as employers to require employees to work from home. They work from home. And the same relationship that existed previously, which is, you're going to work for a certain set period of time, that's got to be in place. Now, employers are going to have to be reasonable during this point in time, because you're asking people to go home. Do they have a spouse at home? Do they have kids at home? Do they have an elderly parent at home? Do they have pets at home? Do they have an office that's equipped at home? They probably don't. Many people wouldn't have an office equipped at home. So there are requirements under the Occupational Health and Safety Act that if before this COVID pandemic, there's many clients that we have that actually do have people work from home. Like if you think of in Canada, what used to be called the call center industry, it's now the customer contact center industry, many of their employees do in fact work from home. And because they plan their employment relationship that way, there's certain health and safety obligations to ensure that they have proper working places and all of that, because that is the workplace that the employers bargained for. But here, I do not think that we're going to have Ministry of Labor officials going into people's homes and saying that we're not doing a inspection of their workplace because it's intended to be temporary. But the relationship that you had before should continue, subject to you being reasonable as an employer.
The only thing that I would add to that is that there are, of course, I guess, additional privacy and security risks when people are working remotely, and particularly when if they're not used to that environment, or if the employer isn't set up to provide that. So that's something one needs to be particularly careful of. And Brad mentioned the call center industry, because that's been the norm for many of those organizations. They have taken that into account and have kind of locked down special computers that those employees use, or special software that make sure that information will not be copied. A whole lot of stuff is being kind of stood up very quickly, perhaps without the same sort of privacy and security diligence that was necessary. You've probably heard a whole lot of discussion about this platform we're using right now, Zoom, and issues that might present. Another part of the question actually had to do with if they're going to be working someplace else. So if they're going to be working outside of the jurisdiction. And one needs to be mindful of the fact that a number of the provincial health privacy laws and a number of the provincial public sector laws have prohibitions of varying kinds related to allowing personal information or personal health information to be stored outside of the province or outside of Canada, or access from outside of Canada, some of which related to disclosure outside of the province. And so you will need to be particularly careful about if you have an employee who says, oh, well, I have a cottage in the upstate, in the backwoods of Maine, and that's where I'm going to go and shelter in place. That might not be possible for them to continue their employment. And so prohibiting that, obviously you can't allow an employee to cause you, the employer, to break the law and for them to break the law themselves. And so that might have significant impact on the employment relationship and whether or not they're actually able to remain employed.
Great, thank you. Another question from Jeanette Lee around regarding a worker applying for workers' compensation. If they've been in contact with someone that has tested positive, that they work with, can they apply if they're asymptomatic?
No, I think that you have to, I mean, they're going to have to be, they're going to have it, right? So you can't kind of preemptively apply. You're going to have to actually have the condition. And if they apply and they're asymptomatic, I can't see of what benefit they would get from applying. So
Right.
if they're, I don't know what they would receive because there would not be any loss necessarily. I mean, there could be a wage loss component if they're required to self-isolate, but the loss would be very minimal if they apply when they're asymptomatic.
Okay.
And we got to keep in mind when we apply for workers' compensation, there's all kinds of reasons that people do that. Number one is to preserve the claim in the future. Like, for example, if it comes out in 5 years' time that there was some lingering effect of being positive for COVID. Or we also have to keep in mind that in many provinces, when we get treatments under the workers' compensation regime, that's billed through the workers' compensation accident fund and not through Medicare. So, you know, they can apply. If there's not a big loss, I don't see what they really benefit from.
Great, thank you. Another question that came in as people registered was around the reassignment of roles and how does that apply in collective agreements, especially in healthcare where the priority is shifting and the need to move the workforce over. Is that possible under collective agreements?
So the thing about a collective agreement is a collective agreement is its own little code, its own little bundle of rules for your workplace. And they are effectively sacrosanct. So that's why I'm saying in some collective agreements that I've read that say you can't lay off and you must maintain a complement of blah, whatever that number is, you know, you're in a difficult situation in those circumstances. And so when it comes to the reassignment of roles, we have to remember that every collective agreement for the most part has its management rights provision. And so the management rights give us the rights that we had before we were ever unionized to manage our workforce as we saw fit. And every provision that we add in on assignment of roles, on scheduling, we're giving away a management right. So you really do need to look at your collective agreement and see what flexibility you have. And I guess I'd leave this for you. If you look through your collective agreement and you don't see anything that prohibits you from doing that, then it likely is what I'll call a management right for you to engage in that. And once again, you've got to keep everything in perspective. You know, you're going to do such on a temporary basis while you're getting through this COVID pandemic. And once it's over and we're able to return you to your regular duties or regular position, we'll set in place a process to do that.
Perfect, thank you. One last question is around the shortage of personal protection equipment in healthcare, and where we talked about the need to keep people safe and the employers and the employees' role, but with the shortage of equipment, how does that play out?
So, I mean, that is an obligation of the employer. So it's in every statute in Canada. As I mentioned, they all put the requirement to ensure a safe workplace on the employer. But there's all kinds of little sub-duties that's in every statute in Canada as well, like the obligation to supervise. So you have to provide competent trained supervision. The obligation to instruct, right, and to train and to educate, and the obligation to provide the necessary equipment. So that's an obligation that's on you as the employer. If you can't get it, well, then you're going to have to find a workaround if there's some substitute you can use. And remember, personal protective equipment is one way of dealing with a hazard. We always say there's other ways of other control systems through perhaps engineering or redoing a process. So, you know, look at other things that you might be able to do. Like, for example, if I can't meet with you face to face, is there some way? And I think that's why we're seeing certain provinces adopt the telehealth now, because you know, I believe certain provinces that was kind of old hat. You did that, but in some provinces it wasn't. So they're saying, okay, we don't want all these healthcare professionals necessarily having to sit 2 feet across from this patient multiple times a day. So we will bring in a different control. It's not PPE. It's a reworking of the type of work to get around that hazard.
Great. Okay, thank you. There's still a few more questions, but we are out of time. I wanted to extend my gratitude and thanks. I particularly liked the patchwork mosaic. I think there's layers and layers of these mosaics and everything you do and we're experiencing. And also the
really like that we used the word patchwork a few times, but I did like David's, he went from patchwork to mosaic to mess. So I like that. I like that.
It depends on the moment, the mood, and the audience.
That's right. Exactly. And also the legislation in real time. That's, you know, we're living that day by day, and it certainly is an uncertain time, but very.
Yeah, for example, in British Columbia, they just kind of relaxed the data residency obligation for those who are dealing with COVID situations. So this is all very fluid. So anyways, thank you so much for the opportunity to speak with your group.
We appreciate all the great questions. Thank you.
Great. Thank you very much. Have a good day. Take care.
Thanks very much.
Take care, everyone.
Bye-bye.